Hello, everyone. We're going to get started. I'm Hugh Mundy, the director of the Center for Advocacy and Dispute Resolution. I'm here tonight to introduce Eliza Solovier, the executive director of First Defense Legal Aid and a 2013 graduate of the John Marshall Law School. And Eliza will introduce Professor O'Neill. Thanks, Eliza.
Thank you so much, Professor Mundy and the Center for Advocacy and Dispute Resolution. First Defense is really happy to be co-sponsoring this event here. I am to introduce Professor Tim O'Neill. And I think you are here because you know very well his legacy as an academic, as a thinker, as a writer. And if not, you can Google Tim O'Neill, the John Marshall Law School, and you will learn about those things. But I wanted to introduce Professor O'Neill a bit more personally. I was his student, still am, and I run First Defense Legal Aid now, where many of you are part of providing free legal aid to people in police custody in Chicago. 24/7, we always have volunteers on call to actually go to the station and provide representation to those facing custodial interrogation. And so certainly my work was informed by the learning I did with Professor O'Neill in the classroom. And you know, many of you can join in that legacy by volunteering with us if you don't already. I wanted to say too that as a non-traditional law student here at John Marshall, which I'm sure many of you are, Professor O'Neill really provided some personal support. I don't know if it was a shared Polish background or southwest part of Chicago, but there was something familial and something really supportive of having that one person in law school that you felt that with, that gave out punchkis on Punchki Day, and just is such a kind teacher and educator. And so while we can look at his CV and will throughout our careers likely be referencing and citing his work, an important part of the legacy of a teacher is through the students. And so the work that I do and that we can do to apply the learning that he's facilitated with us is part of that legacy. And both academically and personally, he's made a very important impact in my life. And I'm very excited to introduce him and have him share an opportunity to learn with other first defenders here tonight. Thank you for everything, Professor O'Neill. And thank you all for coming. And I'm going to go back to my seat.
What's the old Tom Sawyer line about being present at your funeral and hearing the eulogies? But I can't tell you how excited I am. I get excited about a lot of stuff in law, but I can't tell you how excited I am about this. And especially when Eliza, being one of my former students, asked me to talk to an organization like First Defense. Chicago is so lucky to have an organization like First Defense that coordinates the volunteers and the law students to help people and helping people at the most vulnerable point in the process. Where people are first brought in and they have no idea of what their rights are at all. I mean, First Defense just does such a marvelous job. I hate to mention names because if I mention some names, I should mention everyone, but I certainly want to recognize my wife, Jane Rutherford. Jane was a law professor down the street at DePaul for 25 years. So she's my worst critic, so I have to make sure I impress her here tonight. My grandchildren are supposed to come later. I wouldn't let them come to the talk because they said they weren't prepared. So I said, if you're not prepared, you can't come. But they're going to be here for the cookies later. So anyway. This has been a great opportunity. It's made me think back on the 52 years since we've had the Miranda decision. And as I told my students, but those of you who are my former students are going to know some of the things, obviously, I'm going to be talking about tonight. But what I do tell my students, the one unique perspective that I have on Miranda, I tell them, I said, when I retire at the end of this year, I will be the last professor who will ever be able to tell them where he was the day that Miranda came down. The day that Miranda came down, I was studying for my driver's test, okay? And I really remember this because those of you that were around at the time, it got an enormous amount of publicity. Newsweek and Time and all kinds of publicity, and it's ended up to be something that I've spent. My professor in law school for criminal procedure was Professor Yale Camisar, who was one of the people involved with the Miranda case. So Miranda has kind of, when I was a public defender, Miranda has tailed me throughout my career. So it's something I have some strong feelings about, and it's been wonderful to be able to try to put this together. So I'm going to try to review this, and I'm going to start before Miranda. I'd like to give you some sense about what the United States Supreme Court has done about confessions over the years. And I'm going to start in 1936. There's a case that we talk about in law school called Brown versus Mississippi. Brown versus Mississippi, 1936. This was an egregious set of facts where there was a black African-American defendant who was accused of rape of a white woman, and he was taken and tied to a tree, and he was whipped until he confessed. The U.S. Supreme Court took this case, which was kind of a surprise because they didn't get involved in very many state criminal cases. And one of the reasons they may have been involved, Charles Evans Hughes was the Chief Justice at the time. And Hughes, 4 years before, had been the Chief Justice that had, on his court, that had taken the Scottsboro Boys case. The Scottsboro Boys case, Paul versus Alabama, another egregious set of circumstances. And that was the case, really the first case where the United States Supreme Court ever really got involved with finding that rights in the Bill of Rights could, in some sense, be applied to the states through the 14th Amendment Due Process Clause. So with Scottsboro Boys, we were talking about right to counsel. In Brown, what happened, the court for the very first time found that an involuntary confession was a violation of the 14th Amendment Due Process Clause. They had never held this before. It's the first time they ever reversed a confession coming out of a state case. And Brown was the beginning of a 30-year period. I call it the first era, from 1936 to 1966. The court, as U.S. Supreme Court got very involved in taking involuntary confession cases. They reviewed about 36 or so cases, and they were all concerned with whether confessions that were given during police interrogations were involuntary and therefore inadmissible as due process violations. A number of the cases were argued by Thurgood Marshall. A lot of the cases came out of the Deep South, not all of them, but a lot of them did. And of the cases, about 36 cases in those 30 years, they probably held for the defense about 2/3 of the time. Now, what they were doing, obviously, in 30 years, they were trying to develop a body of law that would give guidance to lower courts so that lower courts could evaluate involuntariness claims to determine whether a confession was therefore inadmissible. As you may know, the voluntariness test goes back to England. It went back a couple hundred years. It had been the traditional test that had been used in England and in the United States, but it became constitutionalized through the 14th Amendment Due Process Clause to the states with the Brown case. So for 30 years, they tried to come up with a workable test, and even the court got discouraged. They would admit that it wasn't a success. And the reason it wasn't a success was not really the court's fault. The reason it wasn't a success is that you simply could not reduce a voluntariness test to 3 or 4 workable prongs. We all like 3-prong tests, 4-prong tests. Well, that's not going to be possible here. The voluntariness test looked at the totality of circumstances, and it considered all factors, objective, subjective. A lot of factors could be considered. The trouble is every case presents a unique fact situation, and as I tell my class, every case is involuntariness is a new spin of the Rubik's Cube. They're all different. So the problem, as one author put it, he said the trouble with the totality of circumstances voluntariness test is that every fact is relevant, but no fact is determinative. So by the 1960s, the Warren Court was looking for a way to evaluate confessions through a more bright line test. Do you have a late pass?
Sorry. Sorry.
It's okay. I have to introduce my grandchildren, Angus and Lucy, and that's my daughter, Erin, and I'm very glad that you were all able to make it. So, by the 1960s, the Warren Court was trying to find a different way of evaluating confessions. What they were looking for was a more bright line rule. They were looking for something that lower courts could use in an easier fashion. And in 1964, it looked like the court had found the solution, and the solution happened to be the Sixth Amendment right to counsel. The case that came down in 1964, it was for those of us in my generation, it was an extreme. The case was just as famous as the Miranda case, although I think today it's been pretty much forgotten. It's been pretty much overruled. The case was called Escobedo versus Illinois. For old timers in Chicago, you might remember this, and I always remember this because in this very room in 2004, John Marshall sponsored a 40th anniversary look at Escobedo. A real nerd's day. It was wonderful. I love this. The 40th anniversary of Escobedo. Danny Escobedo was a character. He was a wise guy. I guess you'd call him a wise guy. In and out of trouble all his life. But it was the first time he had ever been pulled in on a murder. He was pulled in before on small-time offenses, but this time they pulled him in on a murder. And when the Chicago police brought him in for questioning on a Saturday night, he asked for a lawyer. And this guy had a lawyer basically on retainer. He pulled out his lawyer's card. This guy had been around the block a few times. So he said, I want to talk to my lawyer. Well, it's the early 60s. The Chicago police, not surprisingly, said, no, you're not going to talk to your lawyer. Escobedo's lawyer at that time, who was on the card, was a man by the name of Warren Wolfson, who later became a justice of the Illinois Appellate Court. He was also a dean at DePaul Law School down the street. And Warren Wolfson came to talk to us about his memories of the case. And his story was this. He said the family called him that Saturday night and said, Danny's in trouble. Can you go down and help him? And Wolfson told us, he said, I swear the story is true. He said it was a Saturday night and I was on a blind date. And the blind date was not working out. And he said, I was kind of looking for an excuse. So he said, I called my answering service, the kind of thing people did in the old days. They had an answering service. And he found out that the Escobedo family was calling him, and they said they wanted him to come to the police station. He said this was great. He excused himself from the date and went down to the police station. And he told us, he said, honest to God, he said, if the date had been going better, I never would have gotten involved with this case. He swears it's true. So he went to the police station, and he didn't know whether he was going to have a chance to get in. They prevented him from seeing him. They said, no, you can't get in, and he never had a chance to talk to him. So what happens? Danny confesses. The Warren Court takes this case in 1964, and they held for the defense. And what they held was that the Chicago police violated Escobedo's Sixth Amendment right to counsel. And this was a very odd case because what they said was, the point at which a suspect becomes the focus of a police investigation, totally uncharged, just brought in as a suspect. But if you were the focus, whatever that meant, it was the first time they had used that term, if you were the focus of a police investigation, the Sixth Amendment right to counsel attached, therefore Escobedo had a right to ask for a lawyer, therefore the police violated his Sixth Amendment rights when they wouldn't let him see a lawyer. So the Escobedo case established this very bright line for the admissibility of confessions. The problem, of course, was that Escobedo was limited by its facts. Most importantly, Escobedo, remember, this was somebody with experience in the criminal system. It's a nice way of putting it. Experience in the criminal system. He had his own lawyer. He had the card, and he explicitly asked to see his lawyer. The problem the Warren Court realized, though, is what do you do with the less sophisticated people, which make up 98%? What about the young? What about the educably mentally handicapped? What about the less educated? What about just the less sophisticated people who don't have lawyers on retainer like Danny Escobedo? So defense lawyers started thinking what they had to do here was to try to expand Escobedo to those people who didn't know that they had a right to a lawyer. And what defense lawyers said, they said, look, this is in 1964. They said, look, in 1963, Warren Court decides the Gideon case, which we all know. Gideon says the Sixth Amendment right to counsel was selectively incorporated to the states through the 14th Amendment due process clause. The next year, in Escobedo, they said the right to counsel attaches when the suspect is brought in and he's the focus of police interrogation. So if Gideon says you have to have a judge in a courtroom has to tell somebody, look, you have a right to a lawyer and unless you waive it, they said, why don't we do this? Why don't we combine Gideon with Escobedo? So basically what we would have, instead of the public defenders in the courtroom, what we're going to have are station house lawyers. We're going to have lawyers in all the station houses. We're going to, just like we have public defenders assigned to courtrooms. So think about it. As I tell my class, if you combine Gideon with Escobedo, what you get, quite simply, is nuclear fusion. Okay, there is going to be an explosion, because what's going to happen is you'll have effectively ended police interrogation. Once you get lawyers involved at this stage, lawyers are simply going to tell people don't talk. They're never going to answer questions. So what happens? Supreme Court sets it up by granting cert in 4 cases that have one thing in common. None of the suspects in police interrogation requested the help of a lawyer. No one told them they had the right to a lawyer. And, you know, we've learned a little bit. The files have become public over the years about how they selected these cases for Miranda. And there's no question now we know, a woman named Leva Baker did a wonderful job going through the records that were released, that the court, they were specifically looking for people that lack the sophistication of Danny Escobedo. So they get Miranda. There were a guy named Westover, a guy named Sanders. They took state cases, federal cases, but these were people that simply lacked the sophistication. I won't even say lacked the smarts, but just lacked the sophistication to know that they could have even tried to ask for a lawyer. This case is called Miranda versus Arizona. Now, the important thing to remember is that it was briefed and argued as a Sixth Amendment case. This was meant to be a major right to counsel case. So what does the U.S. Supreme Court do? U.S. Supreme Court does a complete 180-degree turn, and they base the decision not on the Sixth Amendment, but they based it on the Fifth Amendment right against self-incrimination, the clause that says that no one shall be compelled in any criminal case to be a witness against himself. Looking back, it's never been exactly clear why they backed away from the Sixth Amendment and took the Fifth. One of the reasons may have been that the court, it was a 5-4 decision. Remember, it was a bitterly divided court. And they may have been worried about the fact that if they truly made this a Sixth Amendment case, nuclear fusion would occur and it would be the end of police interrogation. So in some sense, as I suggest to my students, Miranda may have been a bit of a compromise that the court came up with. It was the end of the Sixth Amendment involvement with police interrogations, and now we move to the Fifth Amendment. Now, as you may know, in the 1970s, what happened to the Sixth Amendment? In the 1970s, the Berger Court essentially overruled Escobedo. And they said, no, the Sixth Amendment doesn't attach when you're in the focus of investigation. It only attaches when there's been some kind of adversary criminal proceedings, when there's an indictment, an information, when you're brought before a judge. So they said it's much later than being the focus of investigation. So we're dealing now just with the Fifth Amendment self-incrimination clause. No person shall be compelled in a criminal case to be a witness against himself. And that's the verb that's important. The verb is important there, compelled. What Miranda essentially held, if you try to figure it out, was that police custodial interrogation per se, just the fact that a person is brought into custodial interrogation, and I always tell my students, I said, describe custodial interrogation for me. And I said, just think of all the movies you've seen, the TV shows you've seen. What does it look like? Yeah, it's a little room. Got a guy at a desk, 2 cops standing over him, the little light bulb. You know, they try to paint a picture like this. And I think this is what the Warren Court was thinking of. This is an atmosphere of compulsion. A person feels like they have to answer a question in that situation. So what the Miranda doctrine really said was, even one question, even the answer to one question in police custodial interrogation is going to be presumed to be compelled, and it's going to be a violation of the Fifth Amendment self-incrimination clause. The atmosphere itself, no matter who you are, no matter how sophisticated you are, you feel compelled to answer. So the issue is there any way to remove this atmosphere of compulsion? And what the Warren Court said is sure. And they suggested what are the now famous Miranda warnings. They said the police have to tell the suspect in custody he has a right to remain silent. Anything he says can be used against him in court. He has the right to a lawyer. If he can't afford one, a lawyer will be appointed for him. The metaphor that I've used for many years in class to try to describe the effect of Miranda warnings. If you're in an atmosphere of compulsion, what do the Miranda warnings do? The Miranda warnings, I use the metaphor of, it's like a Lysol disinfectant. It disinfects the room. If there's an atmosphere of compulsion, if there's an aroma, a bad smell of compulsion, what it is like a Lysol spray that neutralizes that, okay? Now there's something very important to notice here. The court specifically said that this is a way to suppress a confession that is totally separate from the involuntariness test under the 14th Amendment Due Process Clause. It's really important to know that Miranda did not substitute for the voluntariness test. It added an extra test. Now, a confession could be voluntary because the police didn't use any improper tactics to force a person to confess. But a voluntary confession could still be suppressed under Miranda if the police didn't give proper warnings and get a proper waiver to neutralize that atmosphere of compulsion in the room. Now, again, remember, it's hard to, sometimes we forget, bitterly divided, 5-4 decision. The dissents, you read the dissents, and a good number of legal commentators at the time felt the same way, thought Miranda had simply ended all possibility of police interrogation. They said there's never going to be another interrogation. The Miranda warnings, after all, are going to turn everybody into a sophisticated suspect. They're all going to be Danny Escobedo. They're all going to demand a lawyer. Nobody's going to talk to the police. So as we know, the story's over. As we know now, in 2018, we haven't had a single police interrogation in this country in 52 years. Every suspect asked for a lawyer. We all lived happily ever after. Good night, everybody. That, that could have been the story, but it didn't turn out that way. So the question that I want to address tonight is, what happened? What happened in the last 52 years? Well, there's one number that you have to remember here, and this is the number that tells a lot of the story of Miranda during the last 52 years, and that number is 80%. There have been a variety of empirical studies that have been done over the years, and they pretty much all agree on this figure. About 80% of all suspects in custodial interrogation waive their Miranda rights and agree to answer questions. 80%, 4 out of 5. So the question we're asking here tonight is, why? And I'm going to try to address a couple of points, a couple of suggestions. The first thing I want to talk about is that the police really adjusted to Miranda very quickly. I mean, they gave this some thought, and they did a pretty good job. What they did, basically, is to make Miranda work for them instead of working against them. And this is the thing, in a perverse way, a number of people have mentioned this, it actually helped make police kinder and gentler. In the old days, the police would come in perhaps, and it would be, we're going to take over this room, we're in control, let's start barking questions and whatever. Well, giving the Miranda warnings, it put the police a little bit in the role of a judge. It's like they put on a robe. All of a sudden they're here, and they're here to give advice. And I always say that Miranda warnings, it's a little bit like the police equivalent of starting it's like a magician coming out and saying, okay, I want to show you nothing up my sleeve. I'm not trying to fool you. It's a way of building a rapport here. David Simon, who wrote The Wire, which may be the best television show ever made. It is really worth going through every episode. It's brilliant. He also wrote a book called Homicide. And they turned Homicide, of course, into a TV show. He embedded himself. He was a reporter for the Baltimore Sun. And he embedded himself at the Baltimore Police Homicide Division for a year. And I'll never forget reading this in the 80s. He gave an example of how investigators almost always got Miranda waivers in Baltimore. And you see some of this in The Wire. The Wire and Homicide, actually, they did some of this too. But he said, here's what they would do. He said, an investigator would begin by saying, look, buddy, we just want to ask you a few questions. We want to get you out of here as fast as possible. But, you watch TV, you watch movies. We got to tell you a few things. So then they pull out a paper, and they would have the Miranda warnings written on it. And what they would do is this. They'd say, okay, first thing I got to tell you, you have a right to remain silent. Do you understand what they mean by that? And the guy would say, yeah. The cop would say, okay, fine. Put your initials under there to show that I said that. So initial it. Anything you say can be used against you. You understand that? Yeah. Okay, initial there. You have a right to a lawyer. You know what a lawyer is? It's an attorney. You understand you have a right to a lawyer? Yeah. Okay, then initial that. So the guy, it's very interactive. The guy is making his initials. And they finally said, okay, and if you want to, if you can't afford a lawyer, one will be appointed for you. You understand that? So yeah, okay, fine, initial that. Then the officer said, okay, I got through those. Now, just sign the bottom line and we'll get started. And the bottom line is the waiver. But it was the whole idea was by making it interactive and signing things and initialing things, it was like this was just a formality. It was simply a formality. And he said he was amazed. He said this wasn't bludgeoning people. It was just turning a Miranda into this formality and getting them involved in putting their initials on the paper, and then they would begin the interrogation. In looking at that 80% figure, I think the second thing I want to mention too is not to underestimate the urge that all of us have to defend and explain ourselves. If we work in an office and somebody comes up to us and says, hey, I had a wallet on my desk 20 minutes ago. You stole it. Well, I suppose we're lawyers, or we could say, I don't have to answer that. I'm not going to address that. I have a right. We know we don't do that. The first thing we're going to do is just start defending ourselves. We're going to say why we didn't do it. And if we did do it, we're going to come up with an excuse as to why we didn't do it. I mean, we're going to try to explain ourselves one way or the other. About 20 years ago, I wrote a law review article about two works of literature. And they both involved a character making an extended confession to the reader. The first was Albert Camus' novel, The Fall, and the other one was Arthur Miller's play, After the Fall. And what fascinated me about both of these, the novel and the play, in each play, the person making this extended confession about the bad things he had done, each play, the leading role was a lawyer. It was a lawyer. And I wrote about this. I said, why a lawyer? Why would you put a lawyer in this role of someone who's making a complete confession? And what I suggested was the very nature of confession is not simply an admission of doing something or even doing something wrong, but often it's an argument with the purpose of excusing ourselves or trying to justify ourselves to get out of what looks like a bad act. So my point was, in the very act of confessing, a person is often acting as his own lawyer. He's being his own advocate for his view of the truth. So the very act of confession, counterintuitively, is often an act of advocacy. You're doing advocacy by confessing. And I think we've all, when we look at that 80%, 4 to 5 people that want to answer questions, I think we've underestimated just how counterintuitive it is for a person to refuse to respond in the face of accusations. And I think the police, in general, just like the Baltimore police, have fed into this by explaining that Miranda warnings are just a small formality to get through before the suspect can start to defend himself. Look, let's get through this and give us your side of the story. You see that question, you see that line a lot. We want to hear your side of the story. Tell us what happened. It probably was self-defense, wasn't it? Let's talk about it. The third thing I would say we have to consider is the irony of the characteristic that is most important in determining whether a person is one of the 20% who asks for a lawyer and won't talk. And you've probably guessed now what the most common characteristic is for the 20% that refuse to cooperate with the police. Yes, you guessed it, a prior felony conviction. Okay? Unsurprisingly, the people least interested in talking to the police are former felons, people that have been through the system and know the score, the Danny Escobedos. And that's the irony of all this. I think that the biggest irony is the whole purpose of Miranda was to expand the scope of suspects, or the group of suspects asking for a lawyer to get away just from the sophisticated guy like Danny Escobedo. They wanted to extend it to everyone. And the irony is, after 52 years, who's claiming Miranda rights to counsel? It's mostly the sophisticated felons like Danny Escobedo. It's kind of a cruel circle that we've had. It's like we've come right back to 1964, which of course is why the job of FDLA is so crucial, which is why I have so much respect for the work that you're doing, getting involved at the beginning, trying to tell people what their rights are, trying to turn people into sophisticated people. The fourth thing I'd mention is, I think you got to remember this, that for the last half century, the work of the Berger Court, the Rehnquist Court, and the Roberts Court has been to weaken Miranda whenever they could. I always tell students that what they have to remember when they're looking at the Miranda cases is Miranda is a very odd case, because there's 90-some cases that have discussed Miranda issues in the last 52 years. Almost all of them came after the Warren Court. And one of the things that I've contended, other people have too, I don't think there has been a time since maybe around 1973 when there were 5 members of the Supreme Court who actually would have voted for the Miranda decision. I don't think there's ever been 5 members of the court that would have voted for Miranda since 1973. For those of you too young to remember some of the history, in 1968, the Supreme Court became for one of the first times, maybe first time since Dred Scott, the Supreme Court became an issue in a presidential election. Richard Nixon said the Warren Court had been way too soft on criminals, that you had to change these pro-criminal decisions. And Nixon said, if I'm appointed, I'm going to get law and order justices. I think it was the expression they used at the time, law and order justices. Well, Nixon got lucky on a couple of fronts for a while, at least. His luck ran out eventually, but But he was lucky in 68. He got elected by a small margin, and then he was very lucky because within 3 years, he had the chance to appoint 4 justices based on deaths and retirements. He was able to appoint 4 justices. And just to give you the scorecard to remember this, since Nixon in 1968, we have had 19 U.S. Supreme Court appointments. 15 of the U.S. Supreme Court appointments, including Kavanaugh, 15 have come from Republican presidents. Only 4 have come from Democratic presidents in the last half century. Who are those 4 people? They're all sitting on the Supreme Court now. The only people that have been appointed by Democratic presidents in the last half century are sitting on the court now. Now, the interesting thing, though, is that I don't want to demonize Republican appointees. And I want you to remember, who some of these Republican appointees were. Stevens, Blackmun, Souter, Kennedy, O'Connor. These were not necessarily just, hang 'em high type of justices. But nonetheless, the Republicans have controlled the court for a long time. A complete review of these 90 cases, obviously, it's way beyond the scope of the talk. But as criminal lawyers, you know a number of things. You know that a Miranda violation, how is the court weakened Miranda? Well, the U.S. Supreme Court has said that a Miranda violation can be used for impeachment. They said a Miranda violation will not suppress physical evidence. The court has refused ever to clarify the Miranda warnings. They've never gone beyond the original warnings. They said a Miranda waiver doesn't have to be explicitly made, and the list just goes on and on. In fact, there are times the Supreme Court is even referred to Miranda not as a constitutional rule, but as you might be aware of, they call it a prophylactic rule. And that by prophylactic rule, the idea is sometimes when you violate Miranda, it violates the Constitution, the Fifth Amendment, but sometimes it really doesn't, because it's a rule that overprotects. So as you probably know, if you have the choice between getting an involuntary confession ruling or Miranda, you always go for involuntariness because you get more bang for the buck. On an involuntary confession, they can never use that for impeachment. An involuntary confession, they can suppress physical evidence. So Miranda is the weak link here. There's no question Miranda is a weaker remedy. Now, it's true, if you remember in 2000, the Dickerson case, the U.S. Supreme Court directly faced whether they wanted to overrule Miranda. And they refused to do that by a 7-2 vote. But by that time, the horse is out of the barn. The police were a lot comfortable with Miranda rules in the year 2000. In fact, if you look back, there were a number of law enforcement agencies and police departments that filed amicus briefs in Dickerson urging the court to keep Miranda. It's like, hey, we know how to use Miranda. We get 80% waivers anyway. What's the difference? 80%. The fifth point that I would make is the Miranda case has led to some very bad unintended consequences. And the one that I have on the PowerPoint there, I say the Miranda rules have turned into a very effective way of what I call laundering police interrogations. And what I mean is that empirical studies have shown that once courts have determined that there's proper Miranda warnings and waiver, they rarely find a resulting confession to be involuntary. Justice Rehnquist noted this in the Dickerson opinion. He sort of said, hey, as long as, there's no big deal here. If they follow Miranda, they never find it's an involuntary confession. Well, there is no necessary correlation between following Miranda and obtaining a voluntary confession. For example, the police could give very proper Miranda warnings in 5 different languages and get 7 waivers and have it all on written down and whatever. But if the subsequent interrogation is conducted by John Burge and his crew, you might have some serious involuntariness issues. Is there a Miranda problem? Oh, no. Is there an involuntariness problem? Well, yeah. But in too many cases, once a reviewing court finds that Miranda has been followed, you see a tendency in courts to conclude the interrogation is fine. You read so many opinions where they say there's a challenge to the confession here, but we noticed the Miranda rights were read and there was a full waiver and it was fine. The interrogation was fine. That's what I mean by laundering confessions. Remember, I said from 1936 to 1966. The Supreme Court decided about 36 cases concerning which confessions were involuntary and inadmissible under the Due Process Clause. And since 1966, the next era, the U.S. Supreme Court's decided about 90 cases dealing with Miranda. So you might ask, okay, since 1960, since the Miranda decision, how many times have they found confessions during custodial interrogation to be involuntary under the Due Process Clause? And I'm going to suggest you write this down. Listen to me. Since 1967, that is the last 51 years, over half a century, the total number of confessions during custodial interrogations that the United States Supreme Court has been found to be involuntary and therefore a violation of due process is, drum roll please, 0. None. Absolutely none. The involuntariness doctrine, there's no question, it's still applied all the time in state courts, it's still applied in lower federal courts, but Miranda has made it less likely to convince these courts that a confession is involuntary. And a lot of lower courts seem to think that as long as you're following Miranda, everything is fine. Moreover, the Supreme Court has completely abandoned looking at the possibility of involuntary confessions in custodial interrogations. They simply they stopped doing it at 66, and they haven't continued. Which leads to my sixth point about the effects of Miranda. It was not geared to address, and it was never meant to address, what clearly is the biggest problem in confession law right now, which we all know, and that's false confessions. And let's be clear, at the time Miranda came down, really you could find a good number of lawyers in the criminal justice system, I think, who would have doubted the very existence of false confessions, that it just didn't happen. Who would be crazy enough to confess to a murder? What really started changing people's thinking was the DNA revolution, of course, in 1989. Now we could conclusively show that convictions were indisputably wrongful convictions. Now we had the scientific evidence. As of a few weeks ago, some statistics here. 1,944 exonerations recorded in the U.S. since 1989. 1,944 people in jail that DNA has determined that they didn't commit the crime. 227 of those had given false confessions to the police. 227 had confessed to the crime that we know positively, absolutely they couldn't have done. That's over 11% of the total number. There's other studies that have indicated that false confessions may be a lot more prevalent. Some of the studies say anywhere from 15 to 24% of wrongful convictions may actually have false confessions with them. And as you know, nowhere is the risk of involuntary and false confessions higher than with young people and with the mentally or intellectually disabled. There was a survey of false confession cases from 1989 to 2012. They found that 42% of the exonerated defendants who were younger than 18 at the time of the crime falsely confessed. 42% falsely confessed. Try this one. 75% of exonerees who were mentally ill or mentally disabled made false confessions. 75%. And you compare this with the false confession rate of adults with no known mental disabilities, just 8%. Okay? To put it another way, only 16% of the exonerees were juveniles, mentally disabled, or both, and yet they accounted for 59% of all the false confessions. So the question is, how do you fix it? How do you fix it? How do you improve Miranda? Well, there was a lot of scholarship that came out a couple of years ago marking the 50th anniversary of Miranda. And one of the best things I saw was written by Professor Tanya Jacoby, who's down the street at Northwestern. And I liked it so much that I invited her to speak here at school earlier this year. And I have the article. You can get a free download of the article. I have it on the PowerPoint there. She wanted a reboot of Miranda, and very appropriately she called it Miranda 2.0. And what she argues is the central problem of Miranda from today's perspective is the fact that it fails to deal with the issue of false confessions. Now, again, remember, in fairness, back in '66, I think there were a lot of people that doubted these things even existed. So this is no criticism of the Warren Court. But Professor Jacoby cites a study which found that 81% of innocent persons, listen to this, 81% of innocent persons waived their Miranda rights, while only 36% of guilty persons did. Okay? In other words, innocent people, by trusting the criminal justice system, the innocent people are increasing their exposure to police interrogation and therefore the resulting risk of actually giving a false confession. That's the irony. And she discusses another factor that increases the risk of false confessions that has no connection at all to the age or to mental abilities of the suspect, and that's the length of the interrogation. One study shown that 34% of false confessions were obtained in interrogations lasting 6 to 12 hours. 39% were the result of interrogations lasting 12 to 24 hours. So we know that the chances of a false confession increase as the time gets longer. And obviously, Miranda had nothing to do with this. I mean, Miranda wasn't concerned with those issues. The Supreme Court's refusal to look at the voluntariness issue for the last half century means we got a serious gap in our case law. But Professor Jacoby also suggests some tweaks to the basic Miranda decision. For example, she criticizes the idea that Miranda warnings are one size fits all. She says that this just isn't the way it should be. And as a matter of fact, if you look at the Miranda opinion, when the court had the so-called famous Miranda warnings, they specifically went out of their way to say, look, we're not creating, this was the expression they used, we're not creating a constitutional straitjacket. All we're doing is giving the basic ideas here of what you want to get across. The irony is that basically those warnings are the ones we're still using today. There are studies that indicate who are the people that have trouble with these warnings. Juveniles and the mentally challenged simply don't understand the warnings. If you're looking for an article, Morgan Cloud from Emory had an article in the University of Chicago Law Review that's been cited numerous times in Illinois cases and federal cases with empirical evidence showing the difficulty that young people and mentally disabled people have just understanding the basic ideas of Miranda. But here, I got some good news. Here, the Illinois legislature has stepped into the breach, and they've had some significant new laws that you should be familiar with. Last year, a new state law went into effect that essentially creates a statutorily created juvenile Miranda right for youths under 18. And what this says, statutorily, it says when you're dealing with kids under 18, the police have to say this. They say, look, this is the quote, "You have the right to remain silent. That means you do not have to say anything. Anything you do can be used against you in court. You have the right to get help from a lawyer. If you cannot pay for a lawyer, the court will get you one free. You can ask for and I love this, you can ask for a lawyer at any time, and you have the right to stop this interview at any time." That has never been added to the Miranda warnings, the idea that people have the control of starting and stopping. But equally important, the law says there has to be 2 follow-up questions to juveniles. After reading this, the officer says, do you want to have a lawyer? So it's almost like the presumption is, I assume you like a lawyer, so do you want to have a lawyer? And the officer, according to statute, is not allowed to proceed until the juvenile actually answers the question. And next, the officer has to ask, do you want to talk to me? And once again, the officer is forbidden to continue until the juvenile answers. The U.S. Supreme Court tells us a recent case called the Burgeis case, where if the people don't answer the questions, they can just plow right on, the U.S. Supreme Court said. But Illinois, the legislature said for kids under 18, you can't do that. Equally important, the same group of under 18 juveniles must have their interrogations videotaped if the confessions are to be used in any felony trial, as well as for certain misdemeanors. And finally, Illinois law now provides that a juvenile under 15 at the time of the commission of either a homicide or a serious sexual assault must be represented by counsel during the entire custodial interrogation. In other words, Miranda warnings are not necessary in these cases because no waiver of counsel is even allowed. Okay? So what's next? After 52 years of Miranda, where do we stand? Well, it's clear that Miranda is a landmark case, and it's a landmark case for good reason. It has its heart in the right place. There is no question about it. But I think what we're learning, we should have learned over the last 50 years, Miranda alone can't solve the confession problem. It's crucial that the Supreme Court get back to developing the concept of what makes a confession involuntary under the Due Process Clause. The court's concentration on Miranda for the last 50 years has been to the detriment of developing a voluntariness doctrine. The last half century has seen so much progress in psychology and neurology and understanding the effects that police questioning can have on innocent suspects. You know, if you have any interest in this, must-see television is Netflix is Making a Murderer. I assume a lot of you have seen it. But when you look at this and watch the police interrogations of Brendan Dassey, the kid, He combines both these qualities. He was young, he was in high school, and he also was apparently a little mentally disabled. And when you see what the police can do with that, and getting this, which anybody who watches it, I think you have to believe is a bogus confession. So what happens? It goes to the Seventh Circuit. On habeas corpus, Steve Drizzen from Northwestern and his group representing him. The Seventh Circuit, in a wonderful opinion by Alana Rovner, a 106-page decision she wrote, finding an involuntary confession. And she just does an enormously wonderful job of describing why it's an involuntary confession. So what happens? As you know, Seventh Circuit unbanked the case. They heard it in a full court. 4-3 decision. They reinstated the conviction. You got to look at the dissent by Judge Rovner in this. Her dissent in the en banc case just excoriates the U.S. Supreme Court's lack of attention to the psychological effects of police interrogation. And she makes this really withering comment. And this is the exact quote. She said, "This is the problem with the U.S. Supreme Court's case law that we have on involuntary confessions." This is the quote. Quote, "Our modern constitutional standards from the U.S. Supreme Court come from a 50-year-old understanding of human behavior," end quote. And she's 100% correct. As I said, U.S. Supreme Court had just stopped looking at voluntariness cases. But the second point is that states have to grow up. And states can't wait for the U.S. Supreme Court to tell them what to do all the time. We live in a federal system, as my students get tired of hearing me say over and over. We live in a federal system. And, you know, what the Illinois legislature's done here in revising Miranda is wonderful. This is the way to have progress in the future. You ain't going to get it from the U.S. Supreme Court for a few years. It's not going to come from Washington. It's going to come at the state level. And finally, I don't have to tell you the single most exciting development in confession law in the last half century has nothing to do with cases. It has nothing to do with case law. It's the videotaped police interrogation. The idea of having a videotaped police interrogation where we can see this and the jury can see it and the judge can see it, I think we're just scratching the surface of how useful this is going to be. And I think eventually this may actually make false confessions a thing of the past. You know, when it first came out, the videotaping, police and prosecutors didn't like it. Generally, they were opposed to it. And you've probably seen that in general, police and prosecutors have come around on this in a lot of ways because they've realized that if you do a good interrogation, this is devastating evidence for a jury to see. If you do it properly and a guy confesses, this is devastating. I thought the most interesting thing was said by a former student of mine who is a prosecutor up in Lake County, Mike Nerheim. And a couple of years ago, Illinois was ready to expand the category of cases in which you had to have videotaped interrogations. And they were going to expand it to another like 8 offenses. They asked Mike Nerheim up in Lake County, the state's attorney, what he thought about it. He said, "I don't like it at all. I'm opposed to this." And he said, "Why are you opposed to the videotaping?" He said, "I'm opposed to it because we should videotape every interrogation." He said, "We love interrogations. We're proud of our police. We want them to see the good work that we're doing. We should have every single interrogation of every case videotaped." So I think this is something that certainly we're going to see a lot more effect in the future. So why am I so confident in the future? Speaking of the future, well, you know why I'm confident, because the future belongs to you, my students. And personally, honestly, it couldn't be in better hands. So at this point, you know, I'm ready. I'm supposed to tell you all the wonderful things that are going to happen in the future. This is the old, you know, commencement speech cliches. And at this point, you're saying, "Let's get to the cookies. I want to get out of here." But I'm not going to do that. Even for you, Gus, I'm not going to do that right now. I'm going to stick to facts, and I'm going to give you a few facts. I want you to listen very carefully, okay? Listen to this. When I became a Cook County public defender, Richard Daley was mayor. No, not that Daley. No, this is the real Mayor Daley. This is the Mayor Daley back in 1968. This is the Mayor Daley who, after the Grant Park riots, said, quote, "The job of the police is not to create disorder. The job of the police is to preserve disorder." That was the Mayor Daley I was talking. Who came when I came on the PD's office. So I started in 1976 down the street at we called it the Civic Center because Daley was still alive. So at the Civic Center, I thought, let's do a little thought experiment. And I wondered what would have happened in 1976 if somebody had given me a list of events. And what they were going to ask me is, okay, look at these events, and we want you to write down which things you think you're going to see happen in the next 42 years by 2018. For example, the first question would have been, are you going to see astronauts walk on the planet Saturn? And I would have said, never going to see it. And I would have been right. They said, are you going to see a total cure for cancer by 2018? I would have said, absolutely not. And I would have been right. I'm on a roll. Next question. In your lifetime, do you expect to see the Cubs win a World Series? I would have said, no, never going to happen. That one I'm wrong about, okay? I'll admit. Next one. Are you ever going to see a woman elected mayor of Chicago? No. You ever going to see an African-American elected mayor of Chicago? No. How about an African-American woman elected Cook County State's attorney? I'd say, come on, get serious. How about an Illinois governor granting clemency to all 167 people on death row in one day? Oh, yeah, when pigs fly, I'm going to see that. How about the Illinois legislature abolishing the death penalty? Not in my lifetime, buddy. How about a chemical test based on genetic material that can establish guilt or innocence of criminal defendants? I would have said, what is genetic material? I don't even know what you're talking about. I can't even answer that one. How about cameras worn on bodies of police? How about cameras on police car dashboards? How about cameras in police interrogation rooms? I would have said that's science fiction. How about the establishment of a torture commission to investigate Chicago police interrogators? I would have said 3 words, you are insane. How about a Supreme Court where we have 3 women justices on the Illinois Supreme Court at the same time we have 3 women justices on the U.S. Supreme Court? Never going to see it. Finally, how about a Chicago cop convicted of murder for shooting an African American in the line of duty? And I would have said, never in my lifetime. And when I look back on this, I can see some astonishing changes that I would never have predicted in a million years. And my hope for you is that in the next 40 years, you're going to have your own list of astonishing changes that you can look back on. The thing is, though, as we all know, these things don't just happen. They require smart people. They require people who organize. They require smart people who are dissatisfied with things. There's a wonderful quote from Nathaniel Hawthorne. Hawthorne said, quote, "The world owes all its onward impulses to men who are ill at ease. The happy man inevitably confines himself within ancient limits." So if I have to give one bit of advice to you, I'd say don't confine yourselves. Keep working, keep dreaming, don't lose faith. Thank you.